The association does not have an alternative dispute resolution procedure. There are two statutes, all of them that govern associations, and they all require associations to make ADR, alternative dispute resolution, available, but they don't require there to be a procedure. This is a constant struggle that associations have with the DCA. The DCA seems to think that the statute mandates associations have a procedure in place, but yet my view, and I think the correct view, is that the statutes require the association to make ADR available as an alternative to litigation, not have a procedure necessarily that's in place. Denied access to ADR. It's clear that the statutes that are applicable to these associations require associations to make ADR available as an alternative to litigation, ADR meaning alternative dispute resolution. And owners, therefore, as far as the DCA is concerned, are going to be allowed to file a complaint to allege that the association has not actually made the ADR available to them as an alternative to litigation. And this ADR is supposed to be available, and by available, one of the key things for available is that the association has to make it available. So if you can do it through volunteers without cost, that's fine. But if it requires you to hire someone outside, a mediator, some other person, then the association has to incur those costs, not the owner that is looking for the ADR. Denied access to accounting and financial records. The applicable statutes require an association to make certain records available. The Condominium Act, for instance, requires associations to keep financial records, accounting records in accordance with certain standards. And then the language specifically then says, that shall be available at all times at reasonable times for owners to inspect. So the DCA provision here, the complaint process would be the owner would allege that some of the financial records that the association is required to keep by statute have not been made available to that owner despite request. Minutes not provided from open meeting. These regulations, the new regulations, now attempt to put very specific controls and obligations onto an association vis-a-vis minutes. So the minutes have to be maintained, they have to be taken, they have to be maintained, they have to be available, they have to provide a certain level of detail. So the DCA form here would allow an owner to simply say, that there's been a meeting that was open to attendance of owners, and these minutes have not been available to me. The complaint form would also contemplate the owner saying that while the minutes were available to me, they weren't in the proper form. They didn't have the necessary information. Appropriate notice for open meeting not given. I use the term board meeting open to attendance of owners as opposed to open meeting because open meeting is oftentimes confused with the owners meeting where owners all gather and they vote on new board members and the like. This is about board meetings that have to take place in a fashion that's open to attendance of all owners. And those meetings have to be noticed in a certain way to the owners. The notice has to be posted, it has to be made available through websites if you have one, it has to be personally delivered to owners via mail or some other mechanism. So that's in the new regulations. It's pretty clearly laid out. And so the DCA is setting up a process where you can identify this as a particular problem and allege that while there was a board meeting, and perhaps while it in fact may have been open to attendance of owners, the notice of it was not adequate, so that people presumably didn't know it took place, or knew it took place but not in enough time to participate or be present. Binding vote taken without the benefit of an open meeting. The statutes have always, as far as I can remember, required that boards make certain binding decisions at meetings that were open to attendance of owners. The current regulations have attempted to make that all binding decisions be made at a board meeting open to attendance of owners. So currently now, based on the new regulations, the board is not supposed to make any decision, regardless of whether it involves privacy or litigation or contracts or whatever the case may be, not supposed to make any of those decisions at a meeting that is not open to attendance of owners. So the DCA has setting up a complaint mechanism here where you could simply identify the fact, I suppose, that there's been a meeting or there's been a decision made. More likely, a decision has been made by the board, yet there was no board meeting that was open to attendance of owners where that meeting or that vote was taken or put into place.